Awesome. All right. Hello. Welcome. I have with me today Ryan McKenna from Barr Picard Law, who is taking the time out of his busy schedule to answer some questions that you might have with regards to legal and your small business. Ryan, thank you so much for taking the time to join us.
Yeah, my pleasure to be here, Jeff. Thanks for having me, and excited to go over some questions about kind of corporate or business law. And if anyone's in the chat, if you have questions about real estate or wills and estates too, I can try and help out with that. But yeah, however we want to go with this.
So why don't you tell us a little bit about yourself?
Sure. As Jeff said there, my name is Ryan McKenna. I'm a lawyer at Barr Picard Law here in Edmonton. I do work primarily in what we call the solicitors department, so corporate, commercial, real estate, and wills and estates work primarily. I went to Boston University for law school and got called to the bar in Massachusetts back in 2016 before moving back to my home Edmonton. Um, about a year later, and then getting called to the bar here in the last couple of years. So I've been practicing here for a bit now, and um, yeah, it's been great, and I'm always excited when we see people with new businesses or old businesses and new problems and ways to help people meet their goals at the end of the day.
Nice. So what initially got you started in law? Why did you choose this field?
So law was always that like pipe dream career that I had since I was a kid. Um, I was the kid in grade two who was like, I want to be a lawyer. I don't know how I actually don't know what the genesis of that was. But over the course of my life, that never really changed. It always seemed like a good, sensible career path, and always continued to be more interesting. And yeah, no second guessing that decision.
Okay, well, since we're here answering questions about small businesses, let's discuss. I have a couple of questions about getting started
Yeah.
with regards to starting a new business. Anyways, one of the questions that I have is regarding your name and what do I need to know about choosing a name for my business?
Okay, so there's a couple things. And one thing I should say off the top before I answer any of these questions is that this should not be considered legal advice. If you guys do want legal advice, please come and talk to me as a client because every situation is different and unique. I'm going to talk about some of the general information that you guys can take with you and some of the general rules to watch out for. But just so everybody knows, this is not individual legal advice in this context.
Yeah.
When with that
Well,
with that disclaimer out of the way.
Disclaimer, yeah.
With respect to the naming question, so it kind of depends on what sort of business you are. So the big thing is that if you are a sole proprietorship, so you're not forming a corporation, you're just going out into business on your own. You can register in Alberta a trade name, which gives you something to operate under. And what you do to get a trade name is you run what's called a nuance search to reserve the name. A trade name can be anything. There's no specific naming requirements to a trade name, other than it doesn't include a a kind of legal type. So it doesn't include the letters limited, corp, corporation, LT or incorporated, LLP, LP. It doesn't include anything to signal that it's some sort of other organization. It's just whatever combination of words other than that you'd like. Now, if you're forming a corporation or some sort of limited partnership like an LP, or if you're an accountant, lawyer, chiropractor, doctor, etc., an LLP, you would then have to put certain legal descriptions at the end of your name. So that would be, for example, Ryan McKenna Ltd. For example, if I were to start a corporation, I could do it with that, but it always has to contain that legal type at the end. Again, to reserve that name in Alberta, you get a nuance search, and you register it when you create your corporation with the corporate registry. Alternatively, with corporations, you can also have what's called a numbered corporation. So Alberta has corporations that are just some number, Alberta, and then Inc. or Limited. And so those are corporations without like a more formalized name. Sometimes they have a separate trade name that they operate under, sometimes not. It all depends on the client's particular use.
So if I'm a sole proprietor, when do you think is the best time, or why would I need a corporation?
So there's a few different considerations that go into starting a corporation. Some of them legal, some of them accounting. So some of them are conversations with Jeff, and some of them would be conversations with me. So really, the advantages and disadvantages of a corporation can be broadly categorized in two spheres, and one is the legal liability side of things, and one is continuous existence, and then the last one is accounting and tax purposes. And so I leave out that third bubble, even though it's definitely the biggest consideration for a lot of people, because that's not my area of expertise. Those are questions for Jeff. So
another live Q&A session.
Yeah, it's another live Q&A session. Maybe we should flip this next time.
Yeah.
But so with the other two, so continuous existence, which I'll also lump in investors. So one advantage to a corporation is that it is its own separate legal entity, a separate legal person. So it's not you. Sometimes people treat them as alter egos of themselves, which works in some cases, but not in others. But a big benefit of a corporation is that no matter if you, the shareholder, dies, lives, etc., you want to bring in more shareholders, the corporation itself continues to exist that whole time. So if you're looking for something that's that's going to last, or that you're going to want to bring other people into, a corporation is obviously the easier route to do that, and gives you kind of a structure to do that. Of course, you can with partnerships as well, but that's slightly more complicated and something that we can get into in maybe another discussion about what the advantages or disadvantages are of a corporation versus a partnership. And then finally, legal liability. So if you're running a business that is subject to particularly high liabilities, like let's say you're running a daycare or a massage therapy place or something, or some kind of paramedical place, where there's a non-trivial chance that if you mess up, you get sued. Having a corporation does provide you some legal shielding from personal liability for whatever dangerous thing the business itself is doing. And so that in particular industries makes a lot of sense, so that you can avoid kind of the negative consequences of being sued, or some of them anyways.
So if I'm looking to incorporate, you had mentioned earlier about the different naming conventions, like limited, incorporated, corporation. So if I'm going to incorporate, how am I choosing which one to go with, or what structure should I go with?
So it's totally up to you. All those three terms mean the same thing as the law goes. The only time it's different is if it's something like a professional corporation. So let's say I've started Ryan McKenna Professional Corporation because I'm a lawyer. I can do that. There are only certain categories of people that can, doctors, lawyers, accountants, etc. But otherwise, it doesn't matter if you picked Inc., Limited, Corp., whatever suits your fancy. By default, in our office, we generally pick Limited, but again, it doesn't matter.
So I guess whatever sounds nice at the end of your name.
Whatever sounds nice. If you want to be Apple Inc. or Apple Ltd., it means the same thing.
Yeah. So what? So if I'm incorporating, you had mentioned limited liability. What are some of the risks that I'm minimizing myself?
Yeah. So really, the big things is that the corporation itself is, again, the legal person. So as long as you're not required to sign some sort of personal guarantee on a loan, the corporation is responsible for the amount of the loan, not you, the shareholder, if you were to take a loan up from a bank. If somebody slips and falls on your corporation's property, it's your corporation that they sue, not you. And for example, let's say you are a sort of paramedical practitioner that doesn't have a personal liability scheme in your industry. In that particular situation, if you were to mess up, or something were to go wrong with a patient of yours, you could theoretically avoid some of that liability as well. Now, obviously, all of those things come with some asterisks, and there is still, if you're a director of the corporation, some liabilities that you could be subject to, as well as some situations where you might be personally liable anyways. For example, in my industry, if I'm a professional corporation and I were to commit some sort of legal malpractice, client can still sue me personally because that's the regime that we have for legal malpractice. And that obviously varies by industry and varies by situation. Directors of the corporation additionally are liable for certain wages. They're liable for certain tax remittances personally. And additionally, a director can be liable for any sort of fraud they commit in the corporation's name. So it definitely limits your liability quite dramatically. But there's a lot of, again, asterisks. And for example, with the loan situation, if you're a new corporation, 90% of the time, I'll tell you the bank is going to ask for a personal guarantee, which puts you on the hook anyways. But it's all kind of situation dependent.
So if I am a director, but yet not a shareholder, am I still liable?
Yeah, so you as a director are liable for those for specifically wages, tax remittances, and frauds you commit in the name of the corporation. So those are the three things that you are responsible for as a director. Most of the time, if you're a director, they will ask for the personal guarantee from you as well as the shareholders, or as well as, pardon me, the voting shareholders that are above about 20%, usually. And again, big asterisk, banks ask for all sorts of different things depending on the situation. But you generally aren't, just like a shareholder, you're generally not liable for things beyond that. And again, shareholders are not liable for those sorts of fraud situations if they're not also directors, because they don't actually act on behalf of the corporation in any way. They merely
that's the big difference. And
yes,
being able to act on behalf of the corporation or not.
Yeah. Yeah, and maybe I should just spell out the difference between a shareholder and a director while we're on the subject. So a shareholder are the people who beneficially own the corporation. Directors are the people who run the day-to-day operations. And so the way that works is that the shareholders who have the voting rights vote and elect the directors to run the corporation. Often when somebody's starting a new small business, it's usually one or two people. They elect themselves every year, and the shareholders and the directors are exactly the same group of people. But as you can imagine, as corporations grow, and just because I brought it up earlier, let's use Apple Inc. as a good example. They're a corporation that's dramatically huge and have shareholders all over the world. And so they elect a board of directors, and those people are often shareholders. And in that case, I believe they all are, but they don't have to be. And these are people who just kind of who manage the corporation day to day. They appoint the officers of the corporation, and they make sure that the corporation ticks along. And then they're accountable to the shareholders every year, because the shareholders can kick them out if they're not doing a good enough job.
So as a shareholder in my business, or a director in my business, what contracts does my business need, if any?
So are you an individual? Like there's no other people in your business?
Let's go with an individual first. Just myself. Do I need any contracts?
Yeah. So you're going to need a number of corporate kind of setup documents. Like you're going to need to have things like bylaws in place for the corporation, sort of original appointing resolutions and that sort of thing. If you're setting up your own corporation, you an individual are setting up a corporation. and just some way to pay for the fact that you have elected yourself the only director. As part of the registration process, you're named the director, and that kind of goes through that way. In terms of other contracts you need, it kind of depends on what your business is doing. So if you're somebody who's acquiring a new business, then you can either do that through some sort of asset or share purchase agreement. It really kind of runs the gamut from there. If you're, for example, like a publisher or something, like you'll probably want some kind of publishing agreement, or you're a land developer, you'll probably want a number of development agreements in place. It all just really sort of depends on how your business is running after that point, after that initial setup of those kind of get those corporate documents in place.
So you had mentioned bylaws. What are bylaws?
So every corporation has to have a set of rules for how it kind of operates called bylaws, or pardon me, how its directors and shareholders operate. And so what bylaws are they're a prescription of rules for how meetings are run, for what directors are allowed to do, for what shareholders are allowed to do, broadly speaking. They also often bylaws will address whether corporations are allowed to borrow money, how they're allowed to borrow, whether they're allowed to open a bank account, anything to that effect. And bylaws differ, and sometimes you'll hear about articles of incorporation. And so the two of them differ in that the articles of incorporation are kind of that very initial base coding of your corporation, if you think in computer terms. And they prescribe what share classes there are, what are the rights and privileges of different shareholders, how can shares be transferred from one to another, how many directors are you allowed to have. And so the articles are the thing that gets filed with the government and are pretty sacrosanct. And then the bylaws are the thing that directors can decide, and the directors can change, and the directors can do whatever. They should get shareholder confirmation, but they don't necessarily need to, and are kind of in the control of the corporation on a day-to-day basis, instead of this longer term can only be changed with significant government amendment.
So if I'm the only shareholder and director, why do I need?
So you should get all these things in place, because whenever you do something, you're often asked for these. So even if you may never run a meeting pursuant to the terms of bylaws, you will always be asked if you're going to get a loan. Your lawyer will ask to review the bylaws, because they're asked by the lender whether your bylaws allow you to do this or not, and whether you are kind of in line with what the bylaws say that you're supposed to do. Again, if you're in a situation where there's any reason that any decision that you've signed off on could be subject to challenge, you want to make sure that you have everything in place that you can say, yes, absolutely, the corporation has the authority to do this, and everything I've signed off on is okay. And often in certain situations, that often comes up in the context of multiple shareholders and not just an individual, because multiple shareholders is typically when you see those kinds of challenges. But it can happen in all sorts of arenas, and obviously the biggest one from our perspective is the financing set and what is kind of expected of you in that realm.
So what other contracts are needed if there's more than one shareholder or director?
So the biggest contract that you'll want if there's more than one shareholder is a document called a unanimous shareholders agreement, or a USA. And so what we call this is kind of like a prenuptial agreement for a business relationship with somebody. And so the reason being is that when you go into business with somebody, it's exactly like getting into a relationship. Everything is good at the start. Everybody's, happy and chipper and moving along. But you have no idea where things are going to go in the future. They can go great. You can be happy forever and never have a problem, or they can go very poorly and things quickly become a disaster. Unlike the divorce statutes, to a measure, the corporate statutes can make the process extremely painful if you and your business partner haven't decided things ahead of time. So what a unanimous shareholder agreement allows you to do is to put in sort of a ground set of rules for what happens when one of you wants to get out. Maybe one of you passes away or becomes otherwise incapacitated. Um, one of you wants to sell your shares to somebody else and the other one doesn't want them to sell them to that other person. Um, and any manner of situations that can come up. You have two shareholders with equal voting rights, and they disagree who to elect as directors, whether it's both of them or one or the other. Um, so there's all manner of problems that can arise, and the corporate statutes are designed to protect um, are designed to protect shareholders' base rights, but are not designed to answer these questions, and are not designed to deal with breakups in any sort of reasonable way. And so, if you haven't pre-decided these questions, you can wind up spending a lot of money on a civil litigation lawyer, taking you through all sorts of remedies, trying to get things solved. And so, part of my job on the solicitor side, instead of in that litigation world, is to try and head these problems off before they start. And a unanimous shareholders agreement is the best way to do that because, again, everybody's happy and you guys can just set clean, clear ground rules that make it easy for you to move in and out of your business as makes sense in your particular situation.
No, I agree. Very, very good document to have in place.
Mm-hmm.
So if I'm ready to incorporate, why can't I just go to the registry to do this? Why do I need to see a lawyer?
Good question. So, as a very basic matter, you could go to a registry, you could register a corporation, and it would validly exist. But again, the big thing is you do not have any sort of audit trail for how your corporation was set up. You don't have bylaws unless you're drafting them yourself. And I can tell you from experience drafting them, that is maybe the most tedious task imaginable. You don't have the kind of, you haven't issued share certificates, you haven't set up a lot of the base rules and appointments that the corporation requires. And so what we would do on the legal side of things is get all that paperwork together, get you guys a good set of articles that make sense for your particular situation, build out your bylaws. Sometimes they have to be custom, sometimes not, but regardless, build that out. Build out your initial resolutions that if you were to ever be audited for some reason that people would look for. Build out your share subscriptions, which set the adjusted cost base of your shares when you start, so that later on, if you were to ever sell, you can figure out what that capital gain is for real. Build you share certificates, and also build out a thing called the minute book of the corporation, which contains all of the corporation's core records, which is something that corporations are required to keep, and are required to keep in some place that is accessible to the public, is the way the statute is worded, with the purposes of shareholders being able to go and inspect them on demand. So we do all of that as part of our incorporation process. And additionally, if somebody was to set up a corporation with us, we always encourage them to also make us the registered office for the corporation, or that place that is open to the public to inspect the minute book, and help them deal with the sort of annual filings that you have to make year on year, as well as the annual resolutions, which help with some other legal liabilities that can come up with a corporation.
Yeah, that annual return seems to be a very forgotten thing that small businesses don't realize that they have to do and often forget to do it.
Yes.
Not very often. It's been very common when I've seen business come to me and their books have been struck, right, and they've been dissolved voluntarily.
Yeah.
Annual returns not being, filed, so it's cleanup that has to be done and costly in order to revive it and file all the annual returns all at once, and
Yeah, no, that can always be ugly. And additionally, and this is maybe just a tidbit of advice for everybody, every corporation in Alberta, every Alberta corporation is required to have audited financial statements every year unless waived. And so if you are a small startup corporation, as Jeff will tell you, having audited financials makes no sense, and is indeed sometimes not possible, and regardless would be very expensive. And if you don't have a paper trail waiving those year on year, and let's say you have a grumpy shareholder one day who says, "Where's my audited financials?" You could be in a world of hurt later on. And having these things taken care of and having somebody who's staying up to date if there's ever a change in the corporate law, having that person there is we think a value to people. And a lot of our clients see value in that sort of thing. Additionally, and this is more just a pitch for our work as a registered office, if we're the registered office for a corporation, we are also the landing place for legal service documents. So as a registered office, one of the ways you're allowed to be served with legal process is by registered mail to the registered office. And when we receive these documents, we are able to review them. We're able to give you some initial advice to let you know whether it's something we can help with, or if we have a referral partner that we can send you out to. And it really provides some extra added value for situations where you're getting those sorts of things landed on you all the time, and have that just initial point of contact ready to go.
I kind of like having a safety net.
Mm-hmm.
Protect yourself so you're not having to think about how much out there grinding and trying to build your business and finding your work. Right?
Mm-hmm. And that's true of that's true across the professions. Like, when it comes to, for example, Jeff's side on accounting, to have an accountant that's, ready to go when your corporate tax returns are due every year. It's the same sort of deal. Like, you want to try and build those long-term relationships with somebody, because then it makes it easier for them to give you kind of long-term planning advice and help, really help your business succeed, because that's that's what we're in the business to do, right? Like, we're not just here to see you once in a while and be like, hey, but like to actually try and help provide meaningful advice where we can. So
yeah. The last question that I had come in was regarding fees. Do you charge? Everyone asks that question. How much is this going to cost me, right?
Yes, no, everybody does. Everybody does. Sorry? No, go ahead.
It's also possible to negotiate like a fixed fee for your services as opposed to like an hourly fee.
Yeah, so our office actually does primarily fixed fee structures, and some of it depends on what you need. So, for example, for a base incorporation, we charge a fixed fee of $750 plus disbursements. And so for viewers out there, a disbursement is kind of an out-of-pocket expense for us. So in the context of incorporation, that would be the Government of Alberta filing fee is the biggest one, which is $275 right now. So that's what we charge for that. Sometimes given a situation where they're doing something else along with it, whether that's like let's say they're doing an incorporation and some sort of large asset purchase, we can kind of roll them together into one kind of broader quote, depending on the nature of the situation. And like I said, something like a USA, like we have it, we start at about $1,500 for that, but it can go kind of all over the place depending on what the individual needs. If you're a person who's setting up a very custom situation, like let's say let's say you're buying a large multifamily building, and we have to set up kind of a very custom USA for you that needs to be signed by 50 plus shareholders or what have you. That can cost quite a bit more because there's some different considerations there. But we always try and work in the context of fixed fees in our corporate world as much as possible, because it provides clients with some certainty, and lets them make that decision with some educated guessing instead of me saying I cost whatever $250 an hour, and so we'll see where that goes. We like to make sure that clients understand what they're getting into so that there's no surprises for anybody.
Yeah, that's good. Well, I'm just saying there's nobody on Facebook right now. No comments have come in. No questions, no additional questions.
Okay.
What actually I was I just had something come to mind. I can't even think of it. I had another question to add. I lost it. Okay.
Yeah.
Comes back to me off.
Yeah. Well, and if anybody does need to contact me, I'm sure in the video that you're viewing post fact, I'll have Jeff post my email, and then I can get some emails from people if anyone's interested. And again, happy to help with all manner of kind of what I call happy law issues. So, buying or selling a home, setting up a will or estate plan. Or of course, as we've talked about throughout this, setting up a business. If you're someone that's looking at maybe a partnership, generally it's not. I'll just say generally it's not our recommendation, but I can certainly talk about that because it's just there's more considerations there if that's something that you're looking at. But definitely happy to discuss that at any time as well.
Do you often don't?
Generally, no. And there's a couple of reasons. So, in the context of a partnership, generally, both partners can bind the partnership, or any number of partners, depending on however many it is, can bind the partnership to any sort of liability, which is a problem in general. All partners have joint and several liability for the partnership, which is flow through, so it's not like a corporation where you're a shareholder. If you're a partner, you're a partner, and they can come after you for the full liability of the partnership, which is often not a good situation to find yourself in. Partnership agreements can become considerably more complex than a lot of corporate agreements can. Now, this is not to say that partnerships don't have some advantages. There's definitely some tax flow through advantages that would fall into Jeff's world that can be useful. Sometimes if you want to have joint and several liability between people, that also can make sense. We see a lot of partnerships between corporations. There are good reasons for that. And then, of course, if you're someone that's setting up a kind of limited partnership, those can also make a lot of sense depending on your situation. For example, doing a financing of like a new condominium building or something, and having all of your finance people come in as limited partners instead of corporate shareholders often makes sense. But that's also a very unique situation. That's not really a question for everybody, but it's something that can certainly come up. So partnerships they're valuable, but they're just generally not the first choice legal vehicle.
How about structuring of like a musician with a band? Partnership? Corporation?
I would probably, if I was the band member, probably vote the corporation. But
Oh, really?
but it all kind of depends on what it is, their needs, what are their concerns, what are they looking to get out of it. Yeah. Because depending on what those things are, you can have different answers, and we can make sure that they get the right set of tools at the end of the day.
Right. You always have to kind of have the future in mind. Right?
Yeah.
The future can change, but you still have to kind of think about what it is that you're trying to attain and accomplish with what you're doing. Right? Mm-hmm. Even though things may change, and that will happen later. But
yeah. Yeah, and keep in mind and keep in mind in my world, sometimes people will refer to lawyers as dream killers. But one thing to keep in mind is that we're trained to think about all of the worst things that could possibly happen all of the time. So that's generally how we will frame advice. is we'll talk about these situations, you know, as if the worst thing possible is happening. So, in the example that we talked about earlier with the unanimous shareholders agreement, um, obviously all of that is assuming that everything goes wrong, or that something goes wrong, because that's what it's there for. Is it's to protect against situations where things go wrong, so they're less bad for you later. And sometimes that's hard to conceptualize upfront, but we really try and make sure that in the long term, you're better off, or you're more protected from problems later. Because if everything works great, then you know, great. I'm I'm always thrilled when nothing goes wrong. But the last thing what we want to see is somebody come to us later and say, "Hey, I didn't get this done. Now there's this problem. How do we fix it?" And then be like, "There isn't really a good way to do that.
Yeah,
Like
right.
it's just gonna, or if there is, it's very expensive to do." And so those are the two situations that are difficult conversations to have because you know there's sort of you can't go back in the past and change things. So so a big part of my job is kind of advising clients up front about what the sort of risks and benefits are, um, and how to protect themselves from as much of the downside as possible.
Mm-hmm. Yeah. Okay. Says we got 2 viewers on Facebook Live.
Hey.
Hey, you guys have any questions? Anything to ask? Comments? Anything? Not, then we'll probably be wrapping this up. Um, my next session, I do have another live Q&A planned for next month. The date has not been set. It'll probably be like the week of November 16th, somewhere around there. And again, this will be on the topic of human resources. So I will be inviting Greg from Impact HR to answer all your HR questions that you might have about small businesses. So again, I want to thank Ryan for taking some time out of your busy schedule. Yeah, any final words from you or advice that you want to impart on us to release?
No, I just want to say thank you for having me again. Thank you for those who tuned in and who will tune in the future. If you need to get a hold of me, definitely feel free to give our firm a call, 780-414-5400. Or alternatively, you can send me an email at the email that will be posted in the description below. As I jump back to my YouTube podcaster days,
Yeah,
like and subscribe,
nice. Yes. Like and subscribe.
ring that bell.
Yeah. If there's any questions that wasn't answered, post in the comments and we will most definitely get an answer.
Definitely.
So take care and enjoy the rest of your week.
Thanks.